and thank you for joining us for the Start Omaha Work Week. Today, we're featuring a crash course for startups that focuses on business entities and entity formation. So just a few quick housekeeping items. All questions can be asked in the question and answer section or in the chat. You're lucky, everyone's flexible today, so they're happy to answer any questions as you ask them. And as a reminder, after each program, you can head to our Beanstack for our community engagement platform, where you can mark that you attended the webinars throughout the week to win some amazing prizes. I'm just going to go ahead and add the link to that in the chat after I introduce our lovely panelists. So we have Michael and Tina from the Coley Jensen law firm. I hope I said that right. Please correct me if I didn't. And it's a local law firm that has a team of over 90 attorneys that are committed to providing over-the-top client service. The team has an extensive and diverse expertise that strives to provide clients with well-rounded legal services and to just help business achieve their success. The two of their attorneys that we have with us today, Michael and Tina, are Tina is a senior associate who practices and focuses on startup matters and guides clients through their venture capital buyouts or minority equity investments. And Michael is an associate whose practice focuses on startups and real estate matters. So I'm gonna hand off to the both of you guys.
Yeah, thank you so much. We just wanted to start off by saying a thank you to TwoSpace for hosting this event, and really excited to be presenting today and talking with y'all. And thank you for your time late on this Tuesday afternoon. And I'll let Tina introduce herself real quick as well.
Yeah, thanks very much, everyone. As Kafaya mentioned, my name's Tina Struck. The focus of our presentation today is to introduce you to the legal basics of entity formation and leave you with some practical tips from a legal perspective. And as Kafaya mentioned, feel free to ask any questions that come up during our presentation using the chat feature. And we'll also save some time at the end for questions. So we hope this to be interactive.
Great, thanks, Tina. So to start off with, just an overview of what we'll be talking about today. We'll briefly talk about why it's important to form an entity, and then we'll move on to the meat of our presentation, which is entity choice and state of incorporation or formation. And then the last three topics we'll talk about are the process of forming an entity, some of the operation and compliance matters you should be aware of, and finally we'll give a few thoughts on how to find a startup lawyer who might be a good fit for your endeavor. So jumping in, why form an entity at all? Well, you might have heard the common phrase that in the eyes of the law, an entity is a person, and what is meant by that is that entities pay taxes, they can be sued, and they can take out loans just like you or I could do any of those things, or with taxes have to do those things. So the real important part for forming an entity is that it offers the owners of the entity protection from liability. So the asterisk on there is there are formalities and operating procedures that need to be followed in order to receive that protection. But if those are followed, then certain lawsuits, if somebody comes into your business and slips and falls, they would sue the entity and not yourself, and that entity can offer some protection to your personal assets and wealth. So that is the driving force for forming entities in most situations. But I just want to note it doesn't offer blanket protection. If you get into a car accident or something like that, and you're not, you're just out on a Friday with some friends, of course the entity is not going to protect you from those matters. But so that's why we form an entity. And like I said, the bulk of our presentation is going to be discussing types of entities that you might form, and also where you might form those entities. So I've said the word entity a lot already. What do I mean by that? Well, common entities for startups include limited liability companies, also known as LLCs, and corporations, which I'm sure many of you are familiar with. We will discuss two types of corporations: a C Corp, which is most likely what you think of when you think of a corporation, and also S corporations, which are similar but different in important ways. And we'll discuss that later in the presentation. Increasing somewhat in popularity, with the keyword being somewhat, are public benefit entities. There's public benefit corporations and LLCs that we'll discuss. These are relatively new entities, and less common entities that we will not be covering in this presentation. But if you have questions on them, please go ahead and drop them in the chat and we'll be happy to address them. Those are partnerships and nonprofit corporations and professional corporations. So with that, I'm going to turn it over to Tina to talk a little bit about LLCs.
All right, so jumping into kind of the meat of the different entity types, we'll start with LLCs. It's a very popular entity form for new companies, and it's probably the form I see most that's used to start with for new businesses. The main advantage of the LLC is flexibility, both in terms of creating like customized ownership arrangements and also being able to convert to another entity type down the road. So for example, down the road, if the company wants to take in money or investments, it's easy to convert to a C Corp, which is required by most institutional investors. And LLCs also have flexibility in terms of how they're taxed. They can be taxed as a pass-through disregarded entity or partnership, or they can be taxed using the C Corp or S Corp structure. So there's just a lot of flexibility, a lot of room to change things and kind of be as creative as you want when you're structuring your ownership arrangements. So next we'll move to corporations generally. As Michael mentioned, corporations are very well known and they're probably what you think of when you think of an entity traditionally. There's two different types of tax structures for corporations. There's C corporations and S corporations, and we'll talk through the key differences between both on the next few slides. The biggest difference in general between corporations and LLCs is that with corporations, you have more record keeping requirements and formalities. So for example, you need a board that's like the main decision-making body of your entity. You have to hold annual board and stockholder meetings or do annual written consent minutes of the board and stockholders instead of holding an in-person meeting. So they can just be a little more burdensome from a record keeping and formalities perspective. So then jumping into C Corp specifically, these are very common for public companies, but less so for small businesses, especially those that are just starting out. An exception to this, though, is when a startup wants to take on institutional investments, such as from a VC firm or angel investors. Those types of investors typically prefer or will even require the entity to be a Delaware C Corp in order to make their investment. And so that's when I talked earlier on LLCs and about how they're flexible in converting, that's where that can kind of come in handy if you start out as an LLC, but then maybe want to merge into a different type of entity in the future. So unlike S Corps, which we'll talk about next, C Corps can have multiple classes or series of stock with different rights and preferences. So in my example earlier, when you're taking on institutional investor money, those investors typically receive a preferred class or series of stock that has special rights. So as an example, like a liquidation preference, meaning that the investor class of stock, if the company were to sell or go public, the investor class of stock gets a guaranteed return on their money before just the common investors. So that's allowed in the C Corp context, but not in the S Corp context. Another key feature of C corporations is that they're subject to double taxation. They're not pass-through taxation entities. And that means that the entity itself pays federal income tax And when money is distributed out to the owners or stockholders of the C Corp as dividends, the individuals also pay tax on that as well. And that's in contrast to the pass-through taxation structure of SCorps, which is a good lead into the next slide on SCorps. So S corporations, like I mentioned, they're pass-through for taxation. They're more common for small businesses than C Corps are because of the, I guess, ease and flexibility of that kind of pass-through taxation structure. But S corporations are not flexible in that you can only have one class of stock. So that means that you can't have, special distribution rights or preferences associated with certain classes of stock, like I mentioned in the C Corp context. In the S Corp context, you can have voting and non-voting classes of stock, but all classes of stock have to be identical in terms of like their economic rights and the economics that they're subject to. Another big kind of limitation or inflexibility of S Corps is that you can only have individuals as owners and certain types of trusts, but generally you can't have any other entities as an owner of an S Corp. And if you don't, comply with these kind of S Corp requirements, then your S Corp will automatically revert back to a C Corp and you'll be subject to that double taxation. So you have to be careful that you comply with the S Corp formalities if you're intending to be an S Corp. One last thing on S Corps is that they can be tax advantageous for businesses that are starting out where the owner is going to be providing services to the company and paying himself or herself a salary. In that specific scenario, you can avoid paying some self-employment taxes if you go the S Corp route.
Thanks, Tina. So one of the last forms of entities we wanted to discuss with you all today is the public benefit corporation and or public benefit limited liability company. As an initial thought, I'll note that these types of entities are not currently permitted by statute in Nebraska. However, they are allowed in Delaware and a handful of other states. So the thing to keep in mind is a public benefit corporation or LLC is for the most part the same as a C corporation or limited liability company. The main differentiator is the public benefit aspect, and we'll discuss a little bit later the formation of these entities, but when you're filing some of the initial paperwork, when you form this entity, you'll include a public benefits statement. For example, one that I came across recently was increasing environmental sustainability by fostering and facilitating the reuse of durable goods. So the entity would put that statement in their certificate of formation or certificate of incorporation, and it allows them some additional flexibility in how they govern the company and manage it to pursue that public benefit. And along with it does come additional reporting requirements. Taking Delaware as an example, if you formed a public benefit LLC there biannually, so every other year you would have to file to your members in the company a public benefit report that needs to be based on standards that have been identified and a couple other items. So there are additional obligations with these entities. Some people will argue that a limited liability company in particular could accomplish the goals of a public benefit limited liability company without the additional reporting obligations, but it can be a useful signal to your customers or to, if you're targeting specific investors, that you are taking a mission seriously enough that you have put it into your governing documents, and again, offering yourselves a little bit of flexibility in how the company is run so you can pursue those objectives. The last note on these entities is that, as I mentioned, they're basically the same as corporations and limited liability companies, except for the public benefit aspect. And so that means they are still taxed and for-profit businesses, just with this public benefit aspect to them. So having discussed a little bit about the types of entities, we want to touch on some initial considerations in the entity formation process. So if you're considering forming an entity, you'll probably initially consider, so I want a limited liability company for the flexibility Tina discussed, or maybe a S corporation fits our needs best. Whatever the case may be, you'll decide on the entity you want to form and then consider where you want to form the entity. So if it's a public benefit entity, you'll know you'll be in Delaware, but other entities or another state that offers it as well. But with other entities, I'm taking Nebraska and Delaware here in the slide. I'm assuming that most folks here are from Nebraska, but you'll want to think about where you're going to operate the business, where do you have employees and property. By picking the state where you have employees and property and operations, you might simplify some of the legal hurdles you have to go through to operate. But incorporating or forming in Delaware or another state is very doable as well. So picking the type of entity and where to form, the next things you'll want to think about is who's going to own the company and how will they pay for that ownership of the company. So for example, if there's two of you and each individual is going to own 50%, maybe you'll pay with money for that initial 50% ownership interest. Perhaps you'll both be working for the company and you will receive the ownership interest for the services you're going to be providing the company. But again, you just want to think through who's going to own it, what percentages, how is it going to be paid for, and probably the last two things you'll want to consider is who's going to run the company's day-to-day operations, and what decisions do the owners feel comfortable delegating to that director in the case of a corporation, or manager perhaps in the case of a limited liability company. To be more concrete, you might be comfortable with the person running the company buying an expensive piece of an equipment without coming to you first for permission, but when it comes to selling the company, you might feel like that's something that everybody needs to agree to. So in the governing documents we'll discuss a little bit later in the presentation, you'll outline those rights of the manager, the person running the company, but you'll want to also have considered items that you think need more approval. So, and finally, I'll briefly touch on the transfers. As you own the company, things will arise where you'll want to transfer it to a third party who might be interested in joining the company, or maybe there's estate planning reasons that necessitate certain transfers of your interest in the company. There are a multitude of provisions that can be put into an agreement to restrict and allow transfers, including when it comes time to sell the company, to facilitate a smooth sale. All these things can be included in the governing documents, and if there's any specific questions on these types of provisions, we'd be happy to answer them, but for brevity, we'll just mention that those are things you'll want to consider when forming an entity. This slide I threw in here just as a quick reference point. I know for many startups, cost is always a big factor in deciding things. And you can see here that when you're forming a C Corp or LLC in Nebraska or Delaware, the initial filing fees might be slightly more expensive in Nebraska, but beyond that, there's greater costs in Delaware. And as Tina mentioned, there is preferences from institutional investors or venture capital firms for Delaware entities. And, it's worth talking to legal counsel or just considering if you're willing to take on some higher costs initially to facilitate that, or if forming initially as a Nebraska entity and then converting into a Delaware entity later on makes more sense. Next, we'll talk a little bit about the entity formation process. And really here, just kind of some checklist items that you can think about when working with legal counsel or doing this. But The first thought is confirm that the name of your entity is available. It'd be a shame if you printed 100 business cards for XYZ Corporation only to find that XYZ Corporation is already formed and you need to pick a new name. So you can do that on the Secretary of State's website. The next thing is filing generally names vary, but it'll be article or certificate of formation for LLCs, and articles or certificate of incorporation for a corporation. That's how you actually form the entity. Then you're going to draft governing documents. These are operating agreements and bylaws that contain some of the provisions I discussed on the last slide about transferring ownership interests and a number of other important matters of how the companies ran. The important thing that is probably not as well known is obtaining a federal EIN. This is basically the company's social security number, so definitely need that. And then you'll apply for a business qualification. This requires a little bit of research as states differ, but if you have employees or property in a state, it's likely that you need to qualify to do business there, and there's a small fee associated with that. And finally, just consider reaching out to an accountant or a tax advisor, as obviously a new entity is being formed that will have some sort of responsibilities, and you want to make sure that you know how to take care of those when the time comes. And I'm going to pass it over to Tina for the next slide.
All right, so on the actual documents that are associated with entity formation and then governance, kind of going forward after you form the entity, from a big picture perspective for both LLCs and corporations, there's a document that's filed with the Secretary of State in whatever state you're forming in that officially forms the entity, and that's a public document that's on file and anyone can access and view it. That's kind of the first big bucket or type of document. And then the other type or bucket is the governing documents that are entered into by the owners of the entity. And it sets forth, their ownership and management rights in the company. And these are not public documents that are filed anywhere. But you do need both types to show to the bank in order to set up a separate account for the LLC, and also to obtain the EIN or the business's social security number, like Michael mentioned. And there's different terminology for these types of documents in the corporate and LLC context, and then also across different states. So for example, in Nebraska, you file what's called a certificate of organization to actually form the LLC. It's called something slightly different in Delaware and other states. And then in Nebraska, for an LLC, you'd enter into what's called an operating agreement. That's the main governing document of the LLC. You can also, if you want, enter into separate like transfer related or buy-sell type agreements that Michael touched on earlier. Or in an LLC context, you can kind of combine those all into one document, which would be the operating agreement. So that's at a high level, the documents that are involved in the LLC context. And then moving to the next slide for corporations. So similarly, as in the LLC context, there's a document that's filed with the Secretary of State that officially forms the entity. For Nebraska corporations, regardless of whether it's a C Corp or an S Corp, these are called articles of incorporation. And then slightly different in the corporate context, the main governing document of a corporation are its bylaws. It typically covers topics such as, when you have those annual board and stockholder meetings that you're required to hold, or, special meetings that aren't on an annual basis, but for, kind of big decisions that come up, how you call those types of meetings. A lot of process-driven provisions are addressed in those bylaws. And also talks about how you appoint, the board or officers, and sometimes, certain committees of the board to make certain decisions. And aside from the bylaws, which are the main governing document, in the corporate context, you enter into kind of separate side agreements that can govern things such as, special voting rights or the stock transfer buy-sell type provisions. It's less common in the corporate context to kind of throw these into one document like you would in the LLC context. And so we're kind of addressing this at a pretty high level, but really aside from, the basic document that forms the entity, there's a lot of different variations and options in the actual governing documents themselves. And that's where your legal counsel will, kind of come in to listen to your needs and what you're looking for in the business and advise you on the structure that best works for you. There's really no one size fits all when it comes to these. And so that is kind of at a high level, the documents that are involved. And so next we'll talk about, properly operating and maintaining your legal entity. And so to take a step back, Michael mentioned this earlier, but the whole reason we form entities is to shield yourself from personal liability, subject to a few exceptions that Michael mentioned earlier. As long as these entity formalities are observed, you won't be personally liable or on the hook if someone sues the business. So, the person suing can't go after your home or your personal assets. Their recourse or their, recovery would be limited to, the money in the business itself. One other exception to this that I just want to make everyone aware of is even if you're operating through an entity, if you sign a personal guarantee, which, a lot of banks will require in connection with getting a business loan, or if the business is buying property, if the bank requires you to sign a personal guarantee and you do, then in that instance, if you default, on the loan or on the property mortgage, you are personally on the hook. So that's one kind of important caveat or exception to be aware of. But going back to my main point, as a general rule, as long as you observe these entity formalities and don't sign any personal guarantees, you won't personally be on the hook for the business's liabilities or debts. So these next few slides will talk about how you properly observe these types of formalities. Okay, so generally, when you're conducting business operations through an entity, you need to hold the business itself out as the legal person that the public is doing business with. So you should never enter into agreements, in your individual name. All company contracts should, clearly list out the company's full name as the party that's entering into the agreement. And you should sign that, on behalf of the company in whatever position you hold. So, the company's the party entering into the agreement. You sign as, for example, the CEO or manager of the company. It's not like, you personally are entering into a contract with someone you're doing business with. That's one really big, important way to keep these entity formalities observed. You also should not combine your personal funds or assets with that of the business. You need to keep those separate. You can't run your personal expenses through the business's bank account. That's a way where it's called, piercing the corporate veil, where that liability separation will not be respected if you do that. And so another way to observe these corporate formalities is, any insurance policies you take out, any other kind of property records, that all should be the business's name. So I keep harping on that, but that's a really big way and a kind of a pitfall where people can, accidentally sign an agreement in their personal name. And then there's an argument out there that, the business wasn't entering into that, it was the person. So one last kind of tip or way to observe these corporate formalities and make sure they're in place is, even if it's not required, we mentioned the LLC context, you have more flexibility where you don't necessarily need to enter into like formal consent minutes that document decisions. If you do that, that just bolsters your argument that you are observing those corporate formalities. So, where appropriate, kind of erring on the side of fully documenting all your business decisions, having, the members or the managers or boards sign off on those and keeping really good records is another way just to make sure that, it really lessens your chance of an argument coming up where the entity and yourself aren't respected as separate legal persons. So on the next slide, as far as ongoing compliance, another way to ensure that your business remains in good standing and as an active separate entity is to send in your annual or Nebraska biannual reports that are required by the state, which Michael mentioned earlier. and pay your business franchise taxes. If you don't do that, then the company can kind of forfeit its corporate powers or entity powers and go back to inactive status, which you can reactivate with appropriate filings and sometimes, paying a fee, but best just not to get in that position in the first place. Also, Michael mentioned this earlier as well, but you should file foreign qualifications. So, in states other than the state where your entity is formed, generally if you have, employees or business locations, but also if you just have like extended dealings with certain states, like let's say you send out, a rep or someone to do sales in a certain state, on a regular basis. State laws vary on this, but generally if you have like sufficient contacts with the state, you need to qualify to do business there as a foreign entity. And that also, helps ensure that in that state, if someone were to sue you, the separate, legal persons of the entity and yourself would be respected. And then the next kind of big area to touch on or consider is, aside from just the basics of forming the entity, observing the corporate formalities, getting all your governance documents in place, there's a number of other areas that you should consider from a legal perspective when you're starting a business. And so a lot of these, self-explanatory, but just to touch on like the key ones. So for employment matters, you may want to enter into employment agreements. Sometimes those aren't appropriate. You just want to have an at-will employment relationship, but documenting like employee policies and a handbook, certain things like that, you should definitely pull in employment counsel to assist you with that. Again, there's a lot of nuance when it comes to specific laws and your specific employee arrangements, but just in general, documenting those kinds of things is important. If you're employing any foreign nationals, you may have to deal with some, immigration or visa laws or matters. It's another big area. For a lot of startups are very IP heavy, you're developing a software or something else like that. And so in that context, it becomes very important to, protect your company's IP and making sure that, others don't have rights to claim that it's theirs or profit from it or use it to their advantage. So a lot of times that means, registering your IP either federally or at the state level, and making sure that your employees and contractors or other service providers enter into appropriate agreements like non-disclosure and confidentiality agreements. Also, invention assignment agreements, meaning that if someone's working for you and they help your business develop IP, it makes it clear that they're assigning those IP rights and ownership rights to the entity. They don't have any claim to them. Appropriately documenting that is really important. I've had a few instances come up where, maybe we got involved in the entity kind of later on and those agreements weren't entered into, and you won't believe the headache it causes when someone has a claim to, your company's IP or your secret, sauce. You don't want them to be able to claim it's theirs. And it's very hard to untangle those without proper documentation. So, getting form agreements like that in place at the forefront and then making sure you consistently have people enter into them as a condition of providing services or being employed by your company is very, very important. Especially in, like I mentioned, I would say most startups I see these days are very tech and IP heavy. So very important. The next bullet on risk management insurance, I mentioned this earlier and I keep harping on it, but it's very important. Make sure you get those policies in the company's name. Make sure you have appropriate levels of coverage and insurance for your specific industry that you're in. And then the last kind of big bucket is just contracts in general. So like vendor agreements or purchase orders, you want to make sure you have these in writing. And, they set out the terms of your business relationship. You actually follow those terms. And if you don't have kind of formal agreements in place, you should be aware that, emails and even conversations can sometimes serve as contracts where you don't otherwise have like formal written agreements in place. So kind of like with the employment issue, getting these forms developed early on, consistently using them can be really important and go a long way from a risk management perspective.
Awesome. One thing Tina made me think of in that topic is, picking the name of a company is a fun thing to do. but when you're going to be using it so often, something very, very small you'll want to consider is, do you want a period between LLC, or are you okay with LLC with no periods? You can maybe make your life going forward a little bit easier by leaving out some extra punctuation marks. So one additional thing to keep in mind, I suppose. In closing today, we wanted to offer some very high level and tips about how to find a startup lawyer. We wanted to also recognize that, startups take different paths, and, when you choose to engage legal counsel may differ depending on the company you're working to start. So with that in mind, here are just a few thoughts on how to find somebody who can help you build the company you're working so hard to start. So, in general, a really great startup lawyer is going to be a holistic practitioner who's well-rounded in general corporate matters and experienced in other areas of law too. But importantly, and not surprisingly, it's always great to have somebody who's worked with startups and is familiar with how fundraising happens, and how to get these governing docs formed in an efficient manner, and what should and should not be in there as it pertains to a startup. To the extent you can, it's always great to have a startup lawyer who knows a little bit about the industry you're entering into. So if that's software as a service, or health technology, or a local bakery, whatever the case may be, to the extent that the attorney is familiar with that industry, it'll help him or her serve you and help you both navigate the space. And finally, attorneys who work with startups might know venture capital firms and other people who are willing to invest in businesses. It's not to say that they're going to get you funding, but it's nice to have somebody who can make a connection or suggest a few names of where to look. The next thing I want to touch on is finding the right fit. So maybe you've identified a couple lawyers who fit the bullet points we just discussed. I would encourage you to think about your funding and growth goals when selecting counsel. Local counsel is going to be great most of the time. Omaha's a big area, again, assuming most of you tuning in are from the Omaha area or Lincoln area. Local counsel can facilitate just about everything you need, but if you do have an idea that you think is going to grow nationally or internationally in a very short period of time, or maybe you're eyeing some funding from a prestigious venture capital firm in California, for those reasons, you might look to a larger firm in those areas that have a network that can help you make those connections. And when you're considering that, I think it's important to think about my next slide here, billing arrangements. Our attorneys work on an hourly fee most of the time, and billing rates can range from $200 to well over $1,000 an hour. And you should not be afraid to ask an attorney what that rate is. There's also alternative fee arrangements, flat fees. If you're looking for a form contract or operating agreement or some of the other documents Tina discussed, it's not unusual for an attorney to agree to prepare that at a set price. Deferred fee would look like an attorney offering services, and then acknowledging that a startup is often sensitive to costs early on, so they might agree to get paid at your next equity raise. And small, but some portion of firms will take equity in the startup company itself. Obviously, how these fees and billing arrangements are met is up to the company. So we just want to provide some thoughts on what is out there and give you the opportunity to think through those options before approaching legal counsel. And finally, some cost-saving measures that you can turn to. There's a website called Cooley Go that has a number of forms prepared for startups. Of course, these are legal documents, so there's always risk in preparing them on your own, and that'll be a decision you have to make. But One thing I will mention is that you can, download this form and start preparing it, and then hand it over to an attorney and ask them to proofread it and touch it up. And that, if you're doing a billable hour rate, that's a way to save some time and money. Clerky, pro bono organizations, there's a wealth of resources on the internet if that's what you're looking to do. In closing, the last note I'll mention is that 2 areas where it might be beneficial to engage legal counsel early on to avoid any unwelcome surprises later on are tax and intellectual property. As Tina mentioned, intellectual property for many startups is their most important and possibly most valuable asset. So engaging legal counsel in this area, which is a complex area of law, might be well worth the investment early on to avoid any unwelcome surprises later on. So our last slide is just answering any questions you guys might have. Thank you again for your time this evening, and let's see if there's any questions.
And yeah, if not, feel free to reach out to us if you do have questions or want to chat more. Don't see any coming in at the moment, but again, we want to also thank DoSpace for having us. Really excited and glad we got a chance to speak with everyone today. Thanks for tuning in. We can give it another minute or so to see if any questions roll in, but looks like maybe we just addressed everything perfectly, so no one has any. Oh, we might have a question. Will we provide the slides? Yeah, we can definitely provide the slides. I think we'll talk to DoSpace and send them out, and then maybe they have a way of sending it to all the participants here today. But yeah, happy to provide them as a resource. What are our names in case we want to reach out? Michael, do you want to maybe go back to the first slide just so they can see them? I don't know how easy or hard that is. And these will also be on the slides when we provide them. But so we're with the Coley Justin Law Firm, as you can see at the bottom of the screen. I'm Tina Struck, and Michael Perney's my co-presenter today. So yeah, thanks everyone for tuning in. Feel free to reach out, and we will provide the slides to DoSpace so they can circulate them to everyone.
Thank you, everyone.
Awesome. Thank you so much, Michael and Tina. So I'm also going to go ahead and put the links to the DoSpace resources. I think I got muted again. So I just put the link to more information about DoSpace for anyone that's interested. And for any questions, you can send us an email at hello@dospace.org. Any questions for Tina or Michael, and we'll make sure to forward it to them. So thank you everyone for joining us today. This has been awesome, and I hope everyone has a wonderful rest of your day. Bye.
Thanks everyone.